Hey folks, Elder Law Care Attorney Patrick Kelleher coming to you from elderlawcare.com. Folks, the question I got today was, how does a divorce affect your estate plan? Okay, I'm going to be answering that question today, folks. So pull up your chair, get your pen out, get your notebook out, and let's talk about that. Folks, numero uno, a divorce, the D word. It's a loss, right? It's like the other D words we talk about in my book. The other D words, unlike fine wine, we don't get better with age. What's that D word? Disability. Most folks become disabled before they pass on. And that's the other D word, death. But divorce is also a loss depending on the circumstances involved. It's typically a loss for all parties involved. And oftentimes, from my experience, folks overlook steps they should take after that divorce or during that divorce process if possible. So typically, when a divorce is filed by law, the divorce court, family court, does not allow changes to be made with assets. Okay? So you won't be able to change typically your asset structure after the divorce petition is filed. At the probate court, there's like a court injunction pause put on all assets until the matter is resolved, either by way of settlement, resolution, or a divorce trial. Most of these matters resolve in settlement resolution. The vast majority of them do. So typically you cannot make any changes in the asset structure until the divorce is complete. And once the divorce is complete, folks, you want to write this down. The first and foremost thing you want to do, update your estate plan, okay? Update your estate plan and say Bill and Mary, long-term married couple, if sadly they go through a divorce later in life, Bill and Mary need to start with a clean slate. They need to update and create a new estate plan with their estate elder law attorney. Well, now it's just Bill, or now it's just Mary, and the significant other is no longer part and parcel. They're no longer your first mate or the co-captain of your plan. You need to change that. You need to change in the plan a couple of big roles in there. Number one, they should no longer serve as your fiduciary helper. What is that? They should no longer serve as your trustee, co-trustee, executor, executrix, personal representative in your will. They should likely also no longer serve as your fiduciary helper in your power of attorney to manage your financial assets in a time of disability, nor should they serve as your healthcare agent to make your medical decisions if you became incapacitated. Okay. Now, there are exceptions where long-term marriages and it's a somewhat amicable civil divorce and they're still like friends and they trust each other. That's rare, but I've seen that on occasion. Usually not the case. Number two, you want to take a look in your treasure chest and you want to look at beneficiary designations on all your assets, okay? And update the beneficiary designations. Not only in your trust, you're going to remove them as a beneficiary, Bill and Mary, okay? But also non-trust assets. Maybe they were a joint owner on your bank account. Maybe they were the beneficiary of your IRA or your qualified retirement account. Maybe they were the beneficiary of your life insurance. I've seen that. Make sure it's updated, folks, okay? That's really, really important, updating beneficiary designation, okay? Also, you want to make sure you take a look at your health insurance, your medical insurance. Are you obligated to still carry Bill or Mary on your health insurance, medical insurance? You want to take a look at that as well and update that accordingly. Also, folks, you want to look at all your emergency contacts. Likely, if you've been married and your trusted first mate or your co-captain, you're going to have them listed at your doctor's office and on your utilities and your backup passwords as your contact person in the event of emergency. With all these organizations from your doctor's office to maybe memberships that you have, you probably have them listed, their name, their telephone number, maybe their email as your contact person, as your helper. You want to make a list. Maybe take a look at your credit card statements. Maybe make sure they're not on contract as a co-user or have a credit card with you and so forth, okay? And lastly, folks, taxes. You want to make sure you take a look at your income tax filing requirements. Are you going to continue to file married filing jointly for the year of the divorce or the following year? Okay, that may be beneficial, maybe significantly beneficial for some of you. Or are you going to put it in your divorce agreement that you're going to file individually the following year? Single, no longer married, right? Talk to your CPA, run the numbers, talk to your financial people, talk to your elder law attorney. All those steps that I just mentioned all need to be reviewed, assessed, and evaluated and taken into consideration. Take action, folks. Make sure you cross the T's, dot the I's. If you found this video helpful, folks, please post a comment and question. Be sure to click on the subscribe button and click that bell because we will keep you updated on other important matters. Strongly recommend pick up a copy of my book on Amazon, Elder Law Attorney Patrick Kelleher, How to Avoid the Metaphorical Four-Headed Monster of Estate Planning and Elder Law, Probate Court, The Tax Man, Financial Creditors and Predators, which is a divorce typically, in-laws turning into outlaws, and also nursing homes. All right, folks. Thanks for joining us here today, folks, at elderlawcare.com.